Welcome, everyone. I'm Kara Griffith, the President and CEO of Tax Analysts. Thank you for joining us today as we discuss recent trends in transfer pricing litigation. Today's event is another in our series of public discussions that we call Taxing Issues. We launched this series in 2020 as another of our efforts to encourage debate on tax issues. We've been bringing the tax community together with leading policymakers and experts for bipartisan discussions on the future of tax policy. While we will occasionally hold in-person events, as we did during the ABA tax section meeting last month, we will continue to hold discussions mainly in a virtual format, and we welcome your feedback on how to make them more interactive. We also welcome your suggestions on future webinar topics. You can send your feedback and suggestions to events@taxanalyst.org. I also want to bring your attention to the fact that there are some background slides available for today's discussion. You can find the slides at the bottom of the viewing page. While the panelists won't be going through the slides, they provide useful background on the cases we'll be discussing. And my last housekeeping note is that we encourage questions for today's event. Thank you to those of you who emailed questions in advance. Please use the chat feature to submit questions during today's event. For our panel discussion, I will begin by asking a few questions, and then I will turn to questions from you, our audience, and I promise to get to as many of your questions as time permits. And now, onto the topic at hand, transfer pricing. The tax technicians tell us that transfer pricing refers to the price that one of a company's subsidiaries charges to another subsidiary for a transaction between them, like buying goods or delivering services. The critics have a different definition. They view transfer pricing basically as a technique that U.S. multinationals use to shift profits from where they really do business to tax havens where they don't. So not surprisingly, the IRS is routinely engaged in lengthy and complex transfer pricing audits. Although some audits are resolved before litigation, some are not. There's been a long string of cases that have made headlines, at least in our world. Litigating transfer pricing disputes is a key part of the IRS's enforcement strategy. But for many years, the taxpayers almost always came out on top. For decades, in fact, taxpayers enjoyed a nearly uninterrupted streak of wins, which means that by definition, the IRS suffered a nearly uninterrupted streak of losses. The agency lost several high-profile cases involving large amounts of money. For example, in litigation before the tax court, the IRS lost in Altera in 2015, in Medtronic in 2016, and in Amazon in 2017. But more recently, things have changed in a big way. Although the Ninth Circuit Court of Appeals upheld the Amazon opinion, the Ninth Circuit reversed the tax court's ruling in Altera in 2019, and the Eighth Circuit vacated the tax court's ruling in Medtronic in 2018. Since then, the IRS has continued its winning ways, and even at the tax court. In November of 2020, the tax court upheld nearly $10 billion in transfer pricing adjustments against Coca-Cola, which meant that the company owed more than $3 billion in taxes. And this past December, the court rejected Coca-Cola's motion for reconsideration. Now, perhaps the IRS is just more aggressive these days than it has been in the past. Early in his tenure, Commissioner Charles Rettig said that when the IRS, and I'm quoting here, brings 5 transfer pricing cases and the court rules against us, you don't have a commissioner who thinks we lost. We're going to wonder why we didn't bring 10. Of course, whether the IRS will continue its winning ways remains to be seen. The tax court conducted a second trial in the Medtronic case, and this past April, Amgen announced that the IRS is demanding more than $3 billion in back taxes. Both cases involve the allocation of profit to a Puerto Rican manufacturing subsidiary, and whether the returns that the company initially allocated are reasonable in light of transfer pricing regulations. Taxpayers are going to need to see how all of these cases are resolved and use that information to predict how the IRS will conduct transfer pricing audits in the future. And thankfully, we have a terrific panel today to discuss these cases and these issues and provide insight into what we might see going forward. So let me introduce them. First, we have Marissa Renson. She's a managing director with KPMG. Marissa also previously spent quite a bit of time with the IRS. Next, we have Matthew Frank, a partner with Steptoe & Johnson. Matthew has a robust career that has included in-house government and advisory roles. And finally, we have Ryan Finley, contributing editor for Tax Notes International and our own in-house transfer pricing guru. I want to thank all three of you for joining us today. This is going to be a fun and very interesting conversation, I have no doubt. Marissa, let me start with you. I have to say, it is really interesting to me that the IRS has gone from losing the majority of its transfer pricing cases and desperately seeking a win, any win, and now they're on a winning streak. So from your perspective, are we actually seeing a new trend? And perhaps you could help us by providing some historical background into how we got to where we are.
Sure. And so, Carrie, as you mentioned, there was, decades of IRS losses. But, I think what was really in people's minds over the last, 15 years or so were a couple more recent and very material losses. So I'll briefly take us through maybe some of that more recent history. So again, one of the biggest losses that was impacting kind of the day-to-day ongoings of the IRS was the loss in Veritas in the tax court in 2009. So this was a case that involved, it was a cost-sharing case, involved a buy-in. And really the issue was the valuation of that buy-in. And at the heart of the issue was really whether compensation was required for some of these softer intangibles that were not listed on the list of intangibles in the regulations that were referenced by the cost-sharing regulations. So a pretty technical issue, but it really came down to a question of what each party was valuing. So the taxpayer made a relatively technical argument about what actually was required to be valued. And the IRS's position was a kind of more economic position based on the concept that maybe a part of a business was transferred. Ultimately, the court rejected the IRS's argument. And this it's akin to a sale of business argument, and held that the IRS abused its discretion. Now, this was maybe a relatively discrete issue, but it had a very big impact on what was happening within the IRS, particularly in appeals. These buy-in fact patterns were very common within the IRS, a big source of controversy, and many of these cases were decided in favor of the taxpayer in IRS appeals because of the loss in Veritas. And then continuing on with this trend, we had the loss in Xilinx for the IRS in the Ninth Circuit in 2010, where it ended up as in the Ninth Circuit. Again, a relatively narrow issue dealing, again, with cost sharing, this time with the treatment of stock-based compensation in the cost pool. Again, relatively narrow issue, but the problem for the IRS really came down to the reasoning of the court. The court held for the taxpayer on the theory that the arm's length standard essentially requires transactions to be priced based on how parties operating at arm's length would behave. And this focus on the behavior of uncontrolled parties created a lot of problems for the IRS that were much broader than this specific issue. It basically allowed taxpayers to take positions that even in transactions that would not maybe happen between uncontrolled parties, they could use comparables that were, close enough, and without the IRS would probably describe it, but in the IRS's view, were not actually comparable. So again, these cases created a problem for the IRS, largely in appeals, because they create a large hazard of litigation for the IRS, and there was a perception that with these big losses, that the IRS wouldn't be able to win a transfer pricing case, even in cases that are very factually different. A couple more losses, I won't dwell on them, but there was the Altera case in the tax court, largely the same issue as in Xilinx, but under a new regulation. There was the tax court decision in Medtronic, not a cost-sharing case, but another loss for the IRS, largely focused on the choice of methods. The IRS was trying to defend its use of the CPM, which is a very commonly used method, and the court rejected that. And there was the Amazon case, which was very similar to the Veritas case, but with more factual development, but again, a loss for the IRS. So again, I think the big problem here was that it was just the ripple effect that these losses were having on the administrative level. And to my mind, where things start to turn around a little bit for the IRS was with the TCJA. So TCJA added a third sentence to Section 482. It basically codified the realistic alternatives and aggregation rules that the IRS often pointed to. It amended the definition of intangible property in Section 367. So it added goodwill, going concern, workforce in place. Also added a broader catch-all phrase. And interestingly, there was a footnote that called out the Veritas and Amazon cases. So you could argue this either way. You could argue that the change in law suggests that maybe the IRS was wrong and needed a legislative change. But I think either way, it was kind of a moral victory for the IRS that at least going forward, a lot of these disputes would be settled in ways that were more favorable to the IRS's historic position. More recently, I'm just going to touch these high level. In Medtronic, the 8th Circuit reversed the tax court and remanded for additional factual development. Altera, 9th Circuit reversal was another big win for the IRS, basically upholding the IRS's interpretation of the arm's length standard as something that really could be based more on economics rather than the behavior of uncontrolled parties. Amazon 9th Circuit opinion was really more of a loss for the IRS, and maybe a little partial victory in that there was a footnote with some dicta that essentially suggested that the impact of this case might be limited to cases decided under the old version of the cost sharing regulations and may not be precedential for future cases. And then the big one was the Coca-Cola case, which was just a very large dollar amount for sure. Pretty big victory for the IRS. I think most significantly in upholding the IRS's use of the CPM, which again, pretty commonly used approach by the IRS. So I do think that this history recently created a bit of a trend. Again, maybe not all complete victories, but much better than the historic position of many very, very kind of decisive losses. And so I think, the one takeaway of this is that now I think it's a lot harder for in appeals for this perception that the IRS is just can't win a tax, transfer pricing case to persist. And I think that will change the dynamic to some degree, at least at the administrative level.
Excellent, thank you. I want to ask a similar question to you that I asked to Marissa on whether or not this is a trend, and to get your opinion on, are we seeing a trend where the IRS is now winning? And in your opinion, if so, is it a positive trend that we are seeing?
Well, thanks. And thanks for inviting me to be here. I agree. Marissa laid out the history nicely. I guess I would say two things. One is the TCJA, I don't think it had any impact on the litigation we're seeing. All of the cases that have been decided, the most recent tax year at issue was 2009. So all the decided cases only bring us up through 2009 tax year. All the cases that are pending now, including Amgen and 3M and Facebook, those only bring us up to 2012. So those all obviously substantially predate TCJA. In terms of the history, I wouldn't call it a trend. You can acknowledge a victory or a couple victories, but I don't think there's a trend. In the last 10 years, or more than 10 years, there really only been 3 sort of traditional transfer pricing cases decided, and I'll supplement that with a couple more. Coca-Cola, Medtronic, and Amazon. So the IRS lost the first, it lost the second, although it gets a do-over because it was remanded, and it substantially won the third. And I say substantially won, I'm talking about Coca-Cola, because there was a substantial issue in there, the dividend offset issue worth $1.8 billion that it lost, which would be real money in any other case. The other 2 cases, Eaton sort of goes under the heading transfer pricing, but it's not a transfer pricing issue so much that's being decided there. They lost that, although that's on appeal, so anything might happen. And Altera, which they won in the 9th Circuit after a lot of work, but you still have an adverse precedent in the tax court elsewhere. That's a mixed bag. That's not a trend in my view. So I find the cases themselves very interesting, but I think talk of a trend or a streak is probably not merited.
I have to say that's really interesting, and when you frame it in that way, it does look a lot different. On I jotted down win-loss next to each case name, and it does look a lot different in that respect. Ryan, let's turn to you, and I'm going to ask sort of the same question in a slightly different way. So we've had the IRS winning at least some cases recently. Is it in fact that the IRS is winning cases, or has the tax court gotten it wrong over the years? And what we're really actually seeing is not necessarily a new trend, but just that the courts have shifted their thinking in how they're deciding cases.
Well, I would say a couple things to that. First of all, I would say that even a mixed bag is probably a trend relative to what we saw before. I mean, 81 and 81 is a lot different from 10 and 152, right? It's even if you look at the recent cases and say it's a mixed bag, I think that's still a departure from maybe if we had this conversation in say March of 2017 when Amazon decided or rather the tax court decided the Amazon case. In terms of characterizing the trend as the IRS's wins versus the tax courts correcting its errors. I mean, obviously views differ on that. I think I would say, and maybe some others would say, that it seems like the commensurate with income standard in the statute was added in 1986, and the regulations that kind of give it effect that were, for the most part, finalized in 1994, that maybe courts have been giving them a little bit more of their due than they did before. In Altera, right? So Altera, you can say Altera is a specific issue, and it was the stock-based compensation, and whether parties to a cost-sharing arrangement have to share it. But it gets at this issue of like whether you have to interpret 482 strictly as kind of a comparables-based, allocation concept, or whether, income, profit, the reasonableness of the sharing of costs. It touches on this broader theme, I think. So when you see it that way, when you see, the IRS's win in Altera, the Eighth Circuit in Medtronic in 2018 saying that, like, whatever happens on remand, the Eighth Circuit certainly rebuked the tax court for not adhering to the regulations, comparability standards for sort of transactional methods. So, I think maybe it's a little bit of a Rorschach test to say whether there's a trend and whether, the tax court was wrong and they're fixing their mistakes. But I do think if you look at those cases, also the 2017, it's a lower profile case, but that Wyckoff case in 2017, where the tax court kind of brushed aside these general criticisms that the comparable profits method, which, as Marissa mentioned, it tends to come up in these cases a lot. It kind of brushed aside these arguments that the CPM is inherently inferior to transactional methods. And you saw that again in Coca-Cola in 2020. So I think there are enough data points here to say that at least the conversation's quite different than it would have been, say, 5 years ago. And in my humble opinion, I would say it's probably where we are now is probably more in keeping with the statute and the regulations than where we were before.
So you mentioned the commensurate with income method. And so I wanted to ask, to you guys, I actually don't know the answer, so I'm going to be very interested in hearing yours. Do you think the commensurate with income method is becoming more accepted now than it was before?
It's certainly being written about. I mean, Ryan had a long piece last month on CWI and its possible impact on 3M. And I'm going to cite Ryan a bunch. Ryan's also written about, CWI before. Stephen Curtis published a big thing in Tax Notes on CWI and Facebook. And he and Jeff Cadet have been sending comment letters to the IRS saying, get busy with CWI and periodic adjustments. In terms of whether it's being more accepted, I think there's a threshold question. What does CWI even mean? The IRS has had the long-standing position that it's consistent with the arm's length standard, and the Ninth Circuit in Altera said yes, it is. Now, I think other people take the view that it's not consistent with the arm's length standard. It's an override to the arm's length standard. So, as I say, there's a threshold question. If you're going to ask is CWI being accepted, well, you first have to define what is it. And I don't think there's any consensus on that, except the IRS sort of longstanding view, affirmed by the Ninth Circuit, that it's just consistent with the arm's length standard.
Yeah, I think there's a different twist on the same point you made, Matt, that there are different kind of views of it. And I think one kind of perception of CWI is just really the periodic adjustment rule that the IRS can use kind of the actual economic results and use that to change, to influence the transfer price and to make adjustments on that basis. I think the other is more of a bigger picture kind of economic concept. And I do think the bigger picture economic concept that, the results of the price should match the economics is certainly being used more in courts. You can see that in Altera. It's part of the IRS's argument. In another case, it's pending Perigo. I would be curious to hear, from you, Matt, or others, just if you've seen more of the first category of more the periodic adjustment use of it, which, personally, I had not seen a big uptick in that use of the CWI rules. But I do think the more broad economic interpretation of it seems to be gaining traction.
So, Marissa, you brought up Perigo. We could jump kind of in that direction as a pending case of interest that I wanted to get your guys' opinions on.
Yeah, it's an interesting case. It's a little bit different from some of the other ones that we've seen. Just a kind of a quick background, the basic fact pattern there is you have Perigo had entered into an agreement with a third party in Israel, Dexel, to kind of develop, manufacture, and sell in the United States a pharmaceutical product. And so Perigo had transferred kind of its rights in this agreement to a new CFC in Israel, and it also had subcontract with that CFC to perform under the agreement. So my understanding was that the CFC didn't have any employees of its own, just had some board members. And so this is a case where the IRS is making some alternative positions. One is based on just economic substance judicial doctrines that the CFC and the transfer was just should not be respected. Another one is a transfer pricing argument based on the CWI rules, particularly using the CPM to price the investment of the CFC in this contract. On the other side, you have the taxpayer's position. Very interestingly, they are using the economics firm of Horst Frisch, using a discounted cash flow method, which is something that you traditionally see the IRS doing. So it's an interesting case. It's just a little bit different than what we've seen, but interestingly, I think either way, there arguably is some benefit to the IRS from this case. Either the courts will presumably bless the discounted cash flow method or agree with the IRS. So it's just an interesting case that's out there that could have some interesting impacts on other cases that are pending.
My quick thoughts on Perigo. I'm not a student of the case. It reminds me of Hospital Corp, because there are really two issues. One is the judicial doctrine. The IRS is arguing a sham and is trying to sham the transaction. And then you have the underlying transfer pricing issues. And so for me, the headline will be whether the court, and by the way, it's in the Federal District Court, Western District of Michigan, not in the tax court. The first question will be whether the judge accepts the IRS sham argument. And then the second question will be, if not, what the traditional transfer pricing result will be, which, as I say, has memories of Hospital Corp, at least as I view it. And that's fully tried. And, that's a case that could be decided any day.
Be interesting to get a case out. Ryan, I wanted to give you an opportunity too. Is Perigo a case you're watching, or are there others that are of interest?
Yeah, well, I'm certainly interested in Perigo. It's interesting, and I'd be definitely interested to see what Matt and Marissa think about this. But I wonder if the government, and in this case, right? I mean, it's not your normal tax court, litigating situation. I assume you have different personnel who are in charge of representing the United States versus those who would represent the IRS and the tax court. I wonder whether the decision to rely on economic substance and sham transaction doctrines has any connection to, the organizationally, the people who are litigating the case, or is this like a perceived glitch in the 482 regs that would allow this without using sort of a sham transaction doctrine? I'm not sure.
It was designated for trial, so we don't have maverick DOJ attorneys running off and making these arguments.
Right.
And I assume when it was designated for trial, it was to make the sham argument. It would surprise me if that weren't the case. I think it's unfortunate. Well, and it's an unfortunate path to go sham rather than transfer pricing. But again, I'm not a student of the case. But this, I'm sure, is coordinated and not a situation.
So if it's a shame, is it a shame because the IRS is right under their alternative argument, Matt?
I do personally. I think it would be a lot more interesting if it is a side entrance or pricing grounds, right? Either way, it's would be another data point there, and the sham would be one of many sham cases if that's the way it goes down. But the side entrance or pricing grounds, I think it provides an interesting decision on a case that again, this idea of how much you can ascribe to the taking on of risk and putting investment, right? Because I think it's undisputed that there aren't any employees of this CFC, but they put in money, they're taking on risk. And that's kind of an open question in a lot of cases. And so I think where the court comes down on that will be informative, even, in very different fact pattern. So I think it'll be an interesting case. And then again, personally, I hope it is the side transfer pricing ground just for that purpose, that the precedent it will create for both sides to have some guideposts in this area.
I mean, it seems that the factual dispute is whether sort of the outcome of those risks was sort of preordained, right? And whether, via the commensurate with income standard, we can just brush aside, what you may have known or not known ahead of time and just sort of look at the ex post economic results of it. I agree. That would be far more interesting than the court just saying that it was a sham. But I'm not sure. I'm not sure how you. Well, it'll be interesting to see what the court decides on that. I don't know.
So this sort of relates to a question that came in from a viewer, which was, does the trend towards using more realistic economic analysis and moving away from arm's length formalism imply that transfer pricing controversies will eventually diminish? Curious to get any of your thoughts on that. Are we going to see less transfer pricing cases if...
There are a couple premises in that question I don't agree with, although I'd have to write them down to tackle them. So transfer arm's length formalism is the term that's used?
Yes, arm's length formalism is the term.
I don't know what that means, but I think I don't agree with it, even though I don't know what it means. I mean, arm's length standard to me has always been very practical. And the virtue of the arm's length standard is that it's practical. It's based on the marketplace. Now, you may have to make accommodations for the fact that arm's length related party transactions aren't mirrored in the marketplace, but still, you've got an actual real life touchstone from which you proceed. And that to me is the opposite of formalism.
Yeah, my perspective on this is that the more decided cases you have out there, the easier it is to resolve a case, before it gets to that point, because you have these different data points to point to. So I think, again, going back to the kind of the IRS's problems before they started having some wins or partial wins, was that all the cases that were out there supported the taxpayer's position. And so you really had to go to court to be able to to point to case law that would support their view and give them kind of some bump in their adjustment as a result of hazards of litigation. But I think once you have more data points out there that you can point to, it becomes easier to resolve a case without going to that point of litigation, because you can compare different cases and say it's more like this one or that one. And both sides have cases they can point to. And personally, I think that makes it easier to resolve a case at the administrative level. I certainly don't think anyone wants to continue a train of litigating every single big case. It's expensive, but once you've put in that effort and have the precedent, I do think it helps to resolve cases at a lower level.
Do you think then, and this was one question we had talked about in advance, do you think that the government is choosing its cases more carefully then, so that it has the cases that it wants to be precedential?
I think to some degree. I mean, the IRS doesn't have perfect control over what cases make it to court or not. I mean, for one, it's just it doesn't have control over which cases might settle an appeal. It could designate a case, but short of that, it's somewhat out of the IRS's hands. That said, I do think that the cases that seem like they would be good candidates for litigation and that have the support of the IRS, they are being very careful about that, making sure that they're staffed very well, being developed very well, putting their best people on it. At the appellate level, same thing, getting really great, DOJ attorneys to argue. So I think there is a lot of thought that goes into that. And if a case doesn't seem like it's ready for litigation, then that case might not be a good one to let go forward and try to resolve again at an administrative level. So I do think there is some degree of thought going into which cases get out the door.
I agree with Marissa. I mean, the cases that the IRS truly chooses are the ones it designates, and I know of three. Right, you've got Amazon.com, which it lost, Coca-Cola, which it mostly won, and Perigo, which is to be decided. I don't know what the history of transfer pricing designated cases are prior to that. I don't know if that's information that's available, but it does seem to be, if we're talking about trends, I mean, I think these three recent designated transfer pricing cases are something new. And, it's 1-1 with one to be decided.
Right. Ryan, I know you wanted to make sure that we brought up 3M. Do you want to take a lead on what is the blocked income exception at issue in 3M?
Sure. So 3M, a case many people have been very eagerly awaiting the outcome of for a little while. It's this blocked income issue, which has to do with when, at least in this case, and as it normally comes up, foreign law prevents a subsidiary, affiliate, whatever, some related party from paying the amount that under the 482 regs and presumably under the treaty, if there is one, that would be considered arm's length. So in 3M, and this is often the case, it involves Brazil and a restriction on the royalties that can be paid. So when Treasury and the IRS sort of overhauled the 482 regs over the course of 93 and 94, they issued these blocked income regs, and they provide a sort of a specific set of relatively strict conditions for when the IRS will say, okay, fine, we will respect that, it's consistent with the arm's length standard, that, you aren't going to charge your affiliate this amount that foreign law won't allow. So those regs came a few decades, I get. Well, I don't recall exactly when the First Security Bank of Utah case came out, but it's the only Supreme Court precedent, relevant to Section 482, and I believe it was 1968. Yeah.
72.
So what's that?
72.
72. I'm sorry. Well, I don't know where I'm coming up with 68. 4 years off. Anyhow, it was a while before, and in this case, and exactly the grounds on which this case was decided it's something that people kind of disagree on, but the result was the Supreme Court held that you cannot, under 482, allocate income to a party in a way that would be inconsistent with any legal prohibitions on the payment or receipt of that payment, right? So fast forward to 3M. In 3M, the dispute is whether these regs are valid under the APA and under Chevron, and whether this First Security Bank case controls. So it's a very interesting issue. Like I believe it came up earlier that this case is holding up Coca-Cola because there was a blocked income issue in that case that was stayed pending 3M. An opinion could come any day. It could come a while from now. No one really knows. But it's a very interesting issue. Whether things like you could debate whether sort of broader issues like whether the commensurate with income standard really has much to say about this. But it's definitely a big issue in its own right. So I think just because of the importance of the issue and allowing other cases to go forward, I think it's a very eagerly anticipated opinion.
I agree. I mean, it's of all the cases pending still, I think it could be the most important case on a number of levels. And it's really interesting because the IRS just lost, not only in First Security Bank of Utah, but in Procter & Gamble and a couple other cases, it lost this issue. And in 1994, as Ryan says, it came out with these regulations, which to many observers just struck someone as defiant. And it set these requirements that the IRS will consider foreign legal restrictions. Doesn't say how they will consider them, but they will consider foreign legal restrictions if you jump through various hoops, which as a practical matter, no one can jump through. And so you've got these adverse court decisions, including a Supreme Court decision, and then subsequent legislative action that seems, as I say, almost in defiance of the Supreme Court and other Court of Appeals decisions. And the validity of those regulations are now under challenge, which, of course, that's a trend, challenging regulations. That's you see that everywhere now, and that was the case in Altera too. But the 3M decision, how it comes down on that question, I think is going to have major ramifications for at least it will express the tax court's view about all these reg challenges, and it will also, I think, address some fundamental questions about 482 and the arm's length standard, whether the regulations are upheld or not. So, it's going to generate a number of conferences and seminars and such talking about the 3M decision whenever it comes down.
If I could just add one thing, I would say how defiant those regs are depends on what you think First Security Bank really says and whether you think the statutory amendment in the meantime bears on the question. And I think it would probably be a minority view to say that the commensurate with income amendment in 1986 changes much, but I do think it's pretty reasonable to argue from First Security Bank itself that case was decided on the basis of old regulations. So whether the IRS, whether Treasury and the IRS are defying something or not depends on what you think sort of the original edict was, and I think there's some dispute over that.
That's absolutely true. First Security Bank of Utah sort of had multiple bases for holdings, the tax parity basis, and I mean, I won't get into detail. There's a tax parity basis, and then there was a absence of distortion, absence of controlled party distortion basis, and that may have been a third basis as well. So discerning its true meaning is like examining the Torah, that you can spend a lot of hours trying to figure it out. And maybe 3M will address that or not. But it's a fascinating case.
There's a little bit of interesting policy overlay too, right? I think at the heart of these regulations is that, should the United States be ceding taxing rights to a foreign country that has transfer pricing rules that don't follow the norms of the rest of the world, basically, if you kind of if you accept the premise that many countries follow OECD transfer pricing guidelines and Brazil does not. So it is it might be interesting to see if that factors in at all, or if that's just deemed to be irrelevant in the case it's decided on the legal words in front of it. But it's I feel like these policy questions are coming up a lot these days in broader international kind of tax world.
Well, so you brought up the international tax implications. Is BEPS going to have any impact on U.S. transfer pricing litigation?
I do think it'll have an impact on the transactions that may or might not ultimately bubble up to litigation. And if you looked at a lot of these cases, I'll take Amazon just because I'm familiar with the facts. You had a transfer from a relatively high tax country to a relatively low tax country, pretty big tax arbitrage, especially before TCJA. I think these days, the tax arbitrage is much smaller, right? The U.S. tax rate has gone down. Companies can't really be kind of storing IP in tax havens anymore. The laws have changed. Many companies are onshoring their IP. If Pillar 2 comes into effect broadly, there will be this 15% minimum tax rate that will, roughly apply everywhere and using different mechanisms. So it takes away a lot of the incentive to engage in aggressive transfer pricing, just because no one wants to be in court if they don't have to be. On the other hand, there are still many countries that have tax rates above the 15%. And so whenever there is an opportunity for tax arbitrage, if the transaction is big enough, it'll still be there. So I suspect the pressure will be taken off, but it's hard to say whether it'll be cut off completely. I'd be curious what others have to say on that point.
I guess I'd say two things. The OECD transfer pricing guidance part of BEPS, I don't think that's going to have a material impact on the course of U.S. transfer pricing litigation. In terms of the tax, sort of international tax reform, it as Marissa says, it may have an impact to the extent it affects international tax planning. But even there, I think you can exaggerate its likely impact. I would tend to think, well, I would point out the following. If you look at the U.S. competent authority inventory, transfer pricing inventory, three quarters of those transfer pricing cases involve foreign adjustments, which means 3/4 of the cases involve foreign governments who think the taxpayer left too much money in the United States, which is not a tax haven. My observation is that transfer pricing adjustments are not so much driven by concerns that you're parking too much money abroad. They're driven by you're not including enough income in the U.S., regardless of the arbitrage opportunities. So
that's a very good point. I agree with that. Definitely, we're seeing a big uptick in the foreign tax authorities and their adjustments. And I think that's a trend that will only continue.
It's interesting, though. I mean, I don't disagree with anything that either of you guys said, but just to speak for people who've said this, a lot of people saw sort of inklings of BEPS in the Coca-Cola opinion. I don't really agree with that, but people said that the whole idea of exercising control, right? The idea that you can reallocate risk based on the degree of control or lack thereof that a party exercises, whether this is a discrepancy between the OECD guidelines and the US regs is itself a matter of dispute, but it's arguably a difference. And some people thought that in the Coca-Cola case, because these, foreign supply points, that was what the foreign subsidiaries were, that they didn't exercise control over marketing activities that supposedly generated the intangibles that entitled them to higher returns than the IRS thought they should receive. That factored into the opinion. I don't really see that. I think that's a stretch, but I do think I've seen arguments in briefs that kind of from the IRS side that at least. Whoa, sorry, I have a screaming cat. Anyhow, lost my train of thought there. But I think I think that you do see it sort of brought in as a secondary argument, and maybe on a sort of subtle level, it is factoring into some opinions now. But again, that's something I think people disagree about.
I would draw a distinction there between what you're seeing at exam and what may be motivating agents, what sort of sources agents are drawing from for inspiration versus what we're seeing in the courts. I mean, I think Coca-Cola would have been written exactly the same way if BEPS never happened, if the OECD guidance never was issued. I don't think it had anything to do with the OECD. But, the IRS is a big organization, and there are a lot of agents pursuing issues, and some of them are inspired by some of the BEPS-related language, and so you do see that on exam. Again, I don't see that seeping through, and I don't think it's going to seep through into court decisions, and partly I draw that from my observations of Canadian practice, where the CRA is heavy on sort of OECD-inspired themes, and the Canadian courts have nothing to do with it.
Yeah, I want to be clear. I don't see this either, but there are people who are saying this. So I'm raising it not necessarily on my own behalf. I agree that Coca-Cola would have come out the same way, regardless. And I think maybe the term control was referring to arguably two different things. In Coca-Cola compared to the OECD guidelines. But, the view is there.
I think it's interesting to try to figure out, and everybody's doing this in many areas, to try to figure out what BEPS is going to mean as it goes, and what are the OECD guidelines as across the board as they come out, and try to figure out how it all fits in. So we haven't, I don't think, spent any or enough time on Altera, because we have to bring this up as a case. It was certainly a landmark decision when it came out. From your opinions, what are the implications of Altera today? And Matt, you kind of brought up the reg challenges and validity and some of those issues. What does Altera mean to that?
Well, Altera upheld the regs, right? So that was a win for the IRS. And I mean, it's hard to talk about Altera without talking about Xilinx and talking about, Altera is one of the most divisive cases in transfer pricing sort of history among, advisors and taxpayers and such. People fall into one of two camps. And so I hesitate to broach the topic when we only have 12 minutes left. I think 3M is going to sort of supplant Altera when it comes to how the tax court, how transfer pricing practitioners sort of view the challenges to transfer pricing regulations. I cited Altera also for affirming the IRS view that CWI is consistent with the arm's length standard. I'm not sure what other sort of long-term lessons I would draw from that case. Well, it does raise a fundamental question, right, about what the focus of the arm's length standard is. And what Altera basically said was the focus of the arm's length of transfer pricing is on the reasonableness of the result, the arm's length nature of the result, not the methods by which you get to the result, and the role of comparables in a proper transfer pricing analysis. And that has lots of important implications. But I don't think I'm going to start down that path in this session. Marissa, maybe you can make.
Yeah, no, I agree. And the part of Altera that's always fascinated me the most is this kind of question about what it means for the arm's length standard. And I think, for many transfer pricing fact patterns, maybe it won't be all that relevant. But I think where it is the most relevant is you have these transfers of what, the IRS had called like the crown jewel IP that's, relatively unique. It's really the kind of the core IP of a company that a company might transfer to a related party, but it would never transfer to a competitor, for example. It wouldn't make sense. And so these are the transactions that are particularly hard for, both, practitioners, IRS to value, because there's a question of whether there really are any comparables for those types of transactions. And I think, the way that the tax court interpreted the arm's length standards is kind of focusing on how uncontrolled parties would behave when you take a transaction and kind of morph it a little bit so that it looks like transactions that uncontrolled parties do enter into. It's a lot easier to find comparables. But if you take the IRS view, where it's arm's length standards really more about economics and the price, and you price the transaction as it was structured, even if it was one that controlled parties wouldn't enter into, it's a different analysis. I think that's a pretty fundamental question that will come up frequently, I think, with these types of kind of unique IP transfer cases. And as far as the day-to-day transfer pricing, maybe much less so. But I do think there's a fundamental question of what the arm's length standard means that Altera took on, and I think answered in a way that was agreeing with the IRS's position. So I do think that will have an impact on how the arm's length standard is interpreted.
There was also sort of an interesting, I don't want to say minor issue, but it didn't get as much sort of attention as this broader comparables versus economics-based approach. It was whether cost sharing arrangements, or specifically the cost sharing payments that are made over time under a cost sharing arrangement, are subject to the commensurate with income standard at all. Because Altera, one of their sort of secondary arguments was that even if the commensurate with income standard would affect the result here, they're saying the IP we transferred to the cost sharing arrangement, okay, that was an IP transfer, but these cost sharing payments that happen over time, the payments that either should have or should not have included the value of stock-based compensation, depending on your position, those are generating new intangibles. So that doesn't relate to any intangible transfer. Personally, I didn't find that argument especially persuasive, but it was definitely all right. There were a lot of amici briefs filed on this exact issue, and it seemed to be important to a lot of tech companies. And the Ninth Circuit said, no, and then, of course, it's just one appeals court, but it's the court where all of our tech companies are. And they held that cost sharing arrangements, including cost sharing payments that take place over time, are subject to the commensurate with income standard, which by its terms only applies to intangible transfers of licenses. So I think that that's important as well.
It is an interesting point. Back to the earlier point of what does CWI mean? Is it refer to periodic adjustments or something broader? Yeah, I think the reason that there is maybe some hesitation in applying the periodic adjustment rules is that there is this question of, can you apply them to a transaction that involves IP and something else? It's might be very rare these days to see a pure IP transfer as opposed to a transfer of IP combined with maybe a service transaction. And there's a question, I think, out there as to whether this commensurate with income standard applies more broadly, or could it apply to like a mixed transaction? And so it's an interesting question. I think it'll be interesting to see kind of where that goes, and if there's any more clarity on that issue in the broader context.
Well, we've thrown out a bunch of cases, a bunch of topics. What does this all mean for taxpayers, and how should taxpayers be responding? How are taxpayers responding? Is there a trend? Is there not? What are your takeaways for taxpayers?
Yeah, I think what we're seeing is that, especially after the Coca-Cola case came out, just because it was such a shock to a lot of people to have such a big case in the IRS's favor. A lot of companies, I think, are just reevaluating their own positions, whether it requires a change or not. They're just, taking a hard look at their transfer pricing policies, taking a hard look at their contracts, and really just seeing, their contracts line up with their policies. Are they, undertaking any transactions that might be inconsistent with those transactions? I think a big question that came up is, in the Coca-Cola case, there was this closing agreement that was not technically applicable to the years at issue other than for penalty purposes. And there was a big debate over, how much weight that carried. I think the court's rejection of that is making a lot of companies think, who may have relied on the old closing agreements or MOUs, or just past audit history or APAs that might have lapsed, and taking some comfort in those, I think it's making them maybe just drawing in question of, is that really a source of comfort, or should they really be kind of just kicking things around a little bit and making sure their documentation is still strong and not overly relying on those past agreements. I think day to day, I don't know that these necessarily are affecting many companies' actual transactions, but just the broader idea that maybe there's a little bit more risk, and that there's a little bit more risk that examiners might be less willing to settle in the same terms, is something that companies should be aware of and prepared for, I think.
I guess my thought is there's a consistency or constancy in transfer pricing litigation. Don't put any weight on trends or trying to predict what's next. There are the major issues 10, 20, 30 years ago are still the major issues now. Well, the best practices from 30 years ago are still the best practices now. Be prepared. Keep your eye on the reasonableness of the result. Every transfer pricing case affirms that what they're evaluating is not the method, but the result. And so no matter what method you put forward as your primary transfer pricing method, you have to keep an eye, as courts do too, on the reasonableness of the result. So if you go back, if you look back 40, 50 years, all the transfer pricing cases that have been litigated, the vast majority of them always have an eye on the distribution of profit between the parties. And so Eli Lilly in the mid-1980s said, profit split is the most commonly used transfer pricing method in courts. And if you look back through the cases, even the cases that purport to use comparable uncontrolled prices or comparable uncontrolled transactions as the primary method, they have one eye on the distribution of profit and whether they think that distribution is reasonable. So I would tell taxpayers, keep your eye on that. You want to be able to show that to the court, not only that you turn square corners and you followed the methods, but that your destination is a destination the court should be, confident of. And if you do that, if you make the court think that that's not just the right result, that is the right result, and that you've gotten to it in a reasonable way, that positions you best for success.
That seems like incredibly wise advice. And, when you look at some of these cases, and as I would consider myself a layperson in the transfer pricing space, that makes absolute 100% sense. One question is, in the 2 minutes that we have remaining that came in from our viewers, was whether COVID has had any impact on transfer pricing formulas and adjustments given supply chain issues. Out of curiosity, I just wonder if you've seen anything that seems awfully recent and that may not be felt for a few years to come. But I'm interested in your opinions on that.
Obviously not in litigation. We'll see it in litigation 8, 10, 15 years from absolutely. Now. At exam, it has not had that as much of an impact on the work of the IRS, but in terms of the sort of results that are being reported by companies in certain industries, it obviously does have an impact. And if you had to sort of discern a theme, is that the IRS will be patient, but they want to see a return. They will, at least for example in the APA program, they'll want to see you work your way out of that shock, and over a multi-year period go back to sort of normal returns. At exam, it's a little bit more difficult because the exam teams are focusing on a single year or two, but those exams, frankly, are just kicking off now.
Yeah, I think there are some structures that might have been structured to put profits in a low tax jurisdiction, and they're now putting losses in a low tax jurisdiction because of COVID. And I think that raises a lot of different issues that I think, ultimately comes down to, the actual arrangement itself as to how that comes out. But I can see those types of transactions being scrutinized, or if companies try to flip and kind of put the profits back in the higher tax jurisdictions, likely be scrutinized. But it'll be interesting to see how that plays out.
Yeah, I guess it'll be interesting to see if it's a blip on the radar, then it may not have as much of an impact as if the trend sort of continues, and it'll be fun to watch. Well, I want to thank you guys. This was very interesting. It was very informative. I enjoyed it thoroughly. I thank you for sharing your time and your insights. And to our viewers, thank you for watching, and we look forward to the next one. Have a great day.
Thank you.